The SADC Lawyers Association has just come out of a two-day roundtable dialogue looking at a critical issue of the state of independence of the judiciary in the SADC region. For some time, concerns have been raised about the interference of governments in some African countries with attacks on the judiciary, and also claims that some of the judiciary have been captured. At a previous SADC-LA gathering, a retired Constitutional Court Judge Zak Yaqub said that an independent judiciary can and must stand between government and the people. Well, to protect the weak and vulnerable human beings from abuse and ensure that all, including government, comply in every element of the Constitution. Well, SADC-LA has released a report on the state of judicial independence in Eswatini, Zimbabwe and Zambia. And to tell us more, I spoke to the CEO of the association, Stanley Nyamanhindi. Perhaps we can begin with a little bit of background as to this report that's come out on judicial independence in Eswatini, Zambia and Zimbabwe. Why the need for this report, and what were you trying to find out?
Where to start is really the challenge, but to be honest, the most important factor to consider is that the legal profession is traditionally charged with supporting or promoting independence of the judiciary, simply because judges can only speak through their judgments and they're not allowed through their voices to voice any dissent. So where there's any attacks on the judiciary, it is the role of the legal profession to speak on their behalf. But more particularly, in the present case, there's been a recent escalation in attacks on the judiciary from the executive arm of government, and this is what has prompted a number of actions by the SADC Lawyers Association that culminated in this report in order to establish evidence of this trend of attacks.
So why Zimbabwe, Zambia and Eswatini?
To be honest, there was no real criteria, but in reality, with Eswatini, there have also been long-standing challenges with independence of the judiciary. Zimbabwe is obviously topical right now with the immediate changes in the constitution that are perceived as detracting from the independence of the judiciary. And I think for Zambia, we also have elections coming through, and there are trends that we are noting where there is a politicization of the judiciary, or should we say judicialization of politics.
All right, so how do you go about assessing the independence of the judiciary? I mean, it is one of those things that's actually quite hard to measure, especially when things are happening behind closed doors, and sometimes judgments can be justified, if not entirely just.
So that was also one of the questions that we had to answer in conceptualizing this research and coming up with empirical evidence on what judicial independence should be as it is defined, but also as it manifests. But the most important thing we were able to do, Peter, is to come up with some indicators that we were able to process and look at to say, how do these show the manifestation of judicial independence? So these indicators are: one, lack of proper separation of powers with impacts on the independence of the judiciary, issues with judicial appointment and removal processes, specifically to do with the transparency of the processes there too. Another indicator was the strength or lack of it of the legal and regulatory frameworks that speak to independence of the judiciary, such as the Constitution. Does it allow the executive to manipulate the judiciary or not? Then we also looked at practices that threaten the impartiality of judges. And interestingly, the evidence shows that these don't only come sometimes from the executive, but from within circles of relations, friendships and backgrounds, and also the sufficiency of the budget that the judiciary works on, because he who feeds you is the one who's probably going to determine, the tune to which you dance. We also looked at the perception of the public in terms of public confidence and issues of judicial corruption and other threats that are physical in reality to the safety of judges.
All right, let's look at some of these countries then. Let's begin with the smallest of the three, Eswatini. Always topical. We have a leader, as in the king, who's an executive president, essentially, as well, not ceremonial by any stretch of the imagination. What did you find there about the judiciary? Is it independent? Is it challenged? What are some of the issues that came through?
So as we were unpacking the report, Peter, we actually had the members of the legal profession in Eswatini join us. And what we looked at is that the trend is that the independence of the judiciary is severely compromised in Eswatini. Now, a clear example is a situation of a new trend of judicial capture and corruption that is coming up in the SADC region. And this is where the head of the judiciary or the leadership in the judiciary, or at least some members of the judiciary, actually act in complicity with the executive, whether advertently or inadvertently, but the end result is that they facilitate capture of the judiciary. And a practice directive that was issued by the late Chief Justice Ramodibedi, may his soul rest in peace, in Eswatini, whereby all the judges and judicial officers were actually barred from taking on cases that had to do with suing the king in Eswatini. This was successfully challenged by the Law Society of Eswatini, but with support from the ICJ and the African Commission of Human and People's Rights. But we need not to get to these levels, yet we are witnessing this.
I just wonder sometimes you make an example of one judge and then do the others fall into line without necessarily being told to?
Well, the truth of the matter is a good number, if not the majority of judges, actually resist actively internal judicial capture or interference. For instance, in Zimbabwe, there was recently a situation where the Chief Justice Malaba issued a practice directive directing the judicial officers to first submit their judgments to his office or to supervisors before these judgments could be made public or handed down. I think we noted a letter from within the judiciary, and we noted an outcry whereby there was resistance to this. And in reality, this practice directive was withdrawn.
Let's talk about Zimbabwe then. What is the state of play there? What did you find in your research?
I think in Zimbabwe, the most important aspect is that we are witnessing, obviously, attacks on the judiciary. And the fact that there is a constitution that is within 8 years old that is being changed in a process that is mostly unilateral and based on executive initiative has been extremely worrying. The real legal principle is that constitutions must be changed in order to enhance democracy and human rights and not to detract. And where they're being changed, there has to be real extensive consultation of all the stakeholders. And this was not seen in the Zimbabwean instance. And certainly analysis has shown that there have been processes that were not correctly followed in coming up with these amendments that now threaten to reduce the transparency and the democratic value that had been added to the judiciary as an institution.
Is this independence being compromised right throughout the levels of the judiciary, right from the district magistrates right up to senior judges? Is this something that you're finding?
In the report, I think it is clear that there is obviously a lot more manipulation of the lower courts. The magistracy is the one where instances of corruption, and even where we witness the Judicial Services Commission itself taking action to censure magistrates from acts of corruption. But we realize as well that sadly, as you go to the upper courts, this is beginning to manifest. And some of the examples are not, in essence, pure corruption of judicial officers, but the circumstances in which they accept to be recruited and to function. And an example that was given in our roundtable is the fact that the finding that the RBZ would have extended loans to members of the judiciary, which loans have not yet been paid, and there is no visible demand for them to be paid. And so the perception might be that they are an inducement. things like if a judge has accepted a farm and is continuing to accept inputs to farm, obviously the challenge is that they may be compromised in their independence. And if I can add, Peter, that the test for independence of the judiciary always must be to say, in the exercise of their functions, what do they fear? They must only fear two things, and two things only. I'm quoting the IBA President Stanford Moyo. This is firstly the fact that they should only be afraid of judicial review in terms of an appeal or in terms of legitimate criticism coming from the legal profession. And once there's any other influencing factor, then we become worried. And certainly in Zimbabwe, there is more than those two factors at play.
One of the things that we've seen quite a bit in Zimbabwe in particular is denying people bail. Some get bail without much effort, depending on which side of the political divide they are, and others just apply and apply and apply and are denied bail. Is this part of the evidence that you see of perhaps a captured judiciary?
In answer to that question, it actually goes back to the immediate aftermath of the last elections in Zimbabwe, where there was shootings on the streets and people were killed. Immediately after that mass action, there were mass trials and detentions that were arbitrary. The SADC Lawyers Association conducted a fact-finding mission together with the International Commission of Jurists, and we did find that the magistrates were actually, within 24 hours, sentencing people to long terms of imprisonment. And we wondered whether that provides enough time for somebody to be heard, for the principles of natural justice to apply. Now, at that time, we talked about weaponization of the courts and the courts becoming politicized as an extension of the executive in order to advance a particular agenda. Of course, the courts were able to say we are not being interfered with and we are not responding to any interference. But recently now, we also realize that there is now systemic denial of bail of certain political prisoners of conscience. And this is definitely worrying and is a sign that a judiciary is not functioning fully independent, or is at least not giving due natural principles of justice as required by international standards to litigants that come before it.
Let's talk a little bit about Zambia. Is the judiciary alive and well there?
Well, the judiciary in Zambia has also been dogged by skirmishes that seem to point to challenges in terms of its independence, especially going towards elections. I think there are few cases that have come before it where people have been applying through some petitions to be amicus curiae in cases where it would have helped the judiciary to function, and they are denied this in circumstances where it is a normal exercise. I think Chapter 1 is one of the foundations in Zambia that has been fighting and has been denied opportunity to give support to the judiciary. We realize that there's been also the systemic judgments that are adverse towards political adversaries of the ruling party, which is something that is also coming up in Zimbabwe. So this is being picked up as a trend where the assets, the freedom, the rights of a political or a perceived political opponent of the president are certainly put under stress or pressure through judicial action.
Is there nowhere that citizens can go if their country's judiciary is letting them down? SADC is a regional body, and it has organs, I believe, that really ought to be helping citizens when their countries have failed them.
This is the paradox of the SADC region, Peter, in that a lot of this, the major prelude was the disbandment of the SADC tribunal, which was an effective regional mechanism for addressing individual human rights violations. And when you look at it, it's also looked at against the background of the attempt, I think, by the Zambian government itself, we have the South African government, to withdraw from the Rome from the Rome Statute. There are different debates as to why these countries should go in or should stay out of the Rome Statute. But the most important thing is that there is a general trend to abstain from platforms of accountability by our governments in SADC. And we believe that even if they want to be accountable, this should not be discretionary. It should be peremptory, and they should facilitate and accept structures that enforce human rights mechanisms.
What can be done? You come up with this report, you observe certain deficiencies and weaknesses. How do we move forward? How do we improve this so that citizens across SADC don't feel like that they are vulnerable to a legal process that might be compromised?
I think the most important thing is the actions such as the one that we are doing, Peter. We are not only wanting to act as the legal profession, but we want to come up with a broad-based civic agency platform that ensures that we supervise the independence of the judiciary, work with the judiciary, and engage with the executive in order to make sure that where things are going well, we do it better, and we transfer best practices to other countries in SADC, because there are other countries which do not have frameworks for judicial independence. But more importantly, there has to be strong resistance to attacks on the judiciary by the legal profession, and the legal profession must not only work on the judiciary, but must also self-introspect, because we cannot have independent judiciaries if we do not have fearless, courageous, and independent bar associations or law societies in the region. And this is the first port of call to make sure that we strengthen the legal profession and we strengthen the judiciary in order to restore and maintain public confidence in the tribunals that they need to assert their rights within.
All right, so before we go, this report on the judicial independence in Eswatini, Zambia and Zimbabwe, is it available to the public? And if so, where can they get it?
The report is available to the public. Our website, www.sadcla.org, under our resources, it's live now. And you could also email us on info@sadcla, SADC-LA.org, and we will generously share this report as we want it to be disseminated as far as possible.